the International PhD in Progress Seminar Series. This is the third phase, I think, that's been organised by the Global South Network. And before I do anything else, I do want to thank Nauman as the organiser of the weekly seminar series, Dr. Nauman Rayat, from the lecturer in law at the Leicester Law School, and also founder and convener of the Global South Network. He's clearly got too much work, but yes, we're very grateful for all of your efforts, Nauman. So I'm Diane Levine. I'm based in the School of Criminology and Sociology here at Leicester. My research is largely focused on building resilient child protection systems for children and young people. Prior to being an academic, I was a teacher and in the civil service for many years, so I feel like I've been around the block a few times. I'm very honoured to be joined by a fantastic peer commentator and discussant for today's session. Our discussant is Dr. Mark Searl. Mark is a lecturer in Canadian law at the Leicester Law School. In this capacity, he contributes to teaching Canadian law modules to students who are enrolled in our LLB, which is there's a Canadian stream, and also the JD Pathway LLB programs. Mark is a specialist in international legal theory, public international law with an emphasis on international human rights law, Canadian human rights law and jurisprudence. Prior to joining the law school, Mark worked for several years as a lawyer in the Federal Public Service in Canada, most recently at the Department of Justice, practicing in the areas of Canadian and international human rights law. Our peer commentator today is Erini Yemenitzis. Forgive me if I apologise if I've pronounced that incorrectly. Erini is currently a PhD candidate at the University of Strathclyde in the UK, where she's currently pursuing her doctorate in the field of law. Erini's areas of interest span the legal field, ranging from competition law to data protection and technology. Her research currently delves into the intricate world, and intricate feels like the right word, of digital platforms within the digital economy. And her primary focus is on the market power held by these digital giants and the regulatory landscapes that govern them across various companies. So, last but absolutely not least, our fabulous guest speaker for today's session is Federico Jorge Gaxiola. Jorge is a Doctorate of Juridical Sciences student from Mexico. He's based at the School of Law at New York University. Jorge worked for about 6 years at the National Supreme Court of Mexico, where he was a judicial assistant to Justice Diaz and Justice Mora, and a law clerk to Justice Carranza. Again, apologies if I pronounced that incorrectly. In 2022, Jorge was professor at Escuela Libre Derecho in Mexico City, where he taught legal theory. Jorge's interests lie in the way in which law deals with and resolves conflicts of values, which feels like a very prescient topic in this current time in which we find ourselves. Particularly, he's interested in researching new challenges to democratic practices, like the proliferation of disinformation, that requires us to adjust our preconceptions about how human rights and democratic processes operate as reciprocal limits and conditions to each other. Jorge will today present their topic titled Conflict of Rights and Moral Remainders in Legal Adjudication, the Case of Defamation. Defamation. Jorge, you've got around 30 to 35 minutes for your presentation. I'll give you a 2-minute warning once you've hit 30 minutes, just so that you know when you're coming towards the end of that period. That will then be followed by about 5 minutes of comments and questions from our discussant and peer commentator, and then we'll open the floor for questions and answers by the attendees. So I'll hand over to you now, Jorge. Very much looking forward to this, and let's crack on.
Thank you very much. Thank you, Diane. I want to thank very quickly the Global South Network, Dr. Nauman Rayat, Diane Levine, Mark Searl, Erini Yemenitzis, and all the attendants. Sorry if I pronounced some of the names wrong. I'm sure I did, but still, I really want to thank you. Thank you for making this possible, organizing this, inviting me. I'm very excited about presenting to you my doctoral project and briefly trying to explain why I'm interested in it, what my tentative arguments are going to be, what some of the challenges that I see ahead, and I would love to hear feedback from you on it. So Diane already said this, but I'm going to repeat it because it's not a short title. So the title of my dissertation is Conflicts of Rights and Moral Remainders in Legal Adjudication, the Case of Defamation. So I'm trying to analyze conflicts of rights on the one hand and moral remainders on the other. And to do that, I use defamation as a case study. And I must admit, why defamation? Because I know defamation a little bit better than other topics in law. That's working on defamation cases. I realize that this may be a problem, but I'm open to hearing from you if you think there are other conflicts of rights in which this link between moral remainders and conflicts of rights can be better understood or presented. Like I'm open to that. I actually think I need, to a certain degree, to think about other examples in which this is important. Okay, so very quickly, I'm going to give a quick overview of the objectives of the doctoral project, which I would say are mainly three. So the first one is to analyze the value of acknowledging moral loss, or what I call moral remainders, and I will explain what that is in a second, and expressing regret when adjudicating conflicts of rights. So whenever rights conflict, one way to see that is to think that something will have to be sacrificed. One of the rights will have to be overridden, and that will entail a moral loss. And I want to analyze whether it's actually valuable for judges to acknowledge that loss and express regret for it. That's the first objective. The second one is to evaluate different approaches to solve human rights conflicts. And I'm going to evaluate according to their capacity to accommodate moral remainders and induce their identification. So if, and this is a conditional statement, if it's valuable to acknowledge moral remainders, then the fact that an approach can better allows us to acknowledge it and it induce us to identify it, that would make this approach, at least in this respect, superior. So I'm going to analyze particularly two approaches, which have been called specification and infringement approaches in ethics. And I'm going to briefly say why I think these approaches are also used in law. And finally, the third objective is to explore some problems related to defamation in civil liability cases, and particularly a doctrine or standard, which is in reality a rule, that's not important, called the actual malice standard. The standard was developed in the US and was later transplanted practically to all legal systems in Latin America. And it establishes that public figures, this includes people who are famous, public officials, or people who have voluntarily injected themselves to an issue of public concern, so public figures, cannot recover damages from false defamatory statements that hinder their reputation unless they prove that the statements were made insincerely. And that means that if the statements were made merely negligently, but not insincerely, like the person was very negligent, the speaker was negligent, he did not verify the information, that doesn't allow the plaintiff, the person who was defamed, to actually recover damages. He must additionally show that the person either knew that the information was false, had knowledge of its falsity, or that he had high suspicions that it was false and he still decided to present it as if it was true anyways. And obviously this standard was developed to protect freedom of speech, which is considered to be central to democratic practices. And I actually have a very strong conviction, which I'm open to change my mind, but I have a very strong conviction that we should keep this standard. It's very important for freedom of speech. And the dangers to freedom of speech should not be underestimated. And particularly coming from a country like Mexico, I'm not underestimating them. But I think that the way in which this standard has been justified presents some problems. And we have better ways to treat people whose reputation is not being redressed after it's damaged, without actually providing economic compensation. We still have many things that we can do to make their situation better. And I think that in order to realize that we can do better, we can do more for them, we need to realize that the fact that reputation does not prevail in its conflict against freedom of speech doesn't mean that reputation did not exist, that there was no moral loss involved. You need to acknowledge the sacrifice that was made. So that's the link between So what I'm trying to say is there is a moral remainder in defamation cases whenever freedom of speech prevails, because the right to reputation did apply to the situation, and it's been sacrificed in order to protect democracy. So we should acknowledge that loss, and we should think what we can do to minimize that loss, even when we're not going to provide economic compensation for it. Okay, so that's the third objective. So very quickly, I want to say, what are some of the problems that I see with the way in which the actual malice standard has been justified? Well, some of these problems have to do with the minimization of harms caused by speech. So in order to try to say that freedom of speech should prevail, one thing that courts usually do is to try to say, oh, words don't really hurt people, actions hurt people. So if words hurt you, it's because you have very thin skin, you're very sensitive, you're too vulnerable. Well, that's one thing that you could do. Another thing that they do is that they try to underestimate, to make invisible the importance of the rights that were overridden. So they will say something like, for example, well, the right to reputation is actually not that important, or probably you waived it when you decided to become a public official, or when you voluntarily accepted to be under the scrutiny of society. And generally, another problem that I think exists in relation to this is that this really doesn't allow us to understand very well the phenomenon of fake news and why it's problematic and how to face it. Because courts have been so insistent in the value of freedom of speech that sometimes it seems that what they're saying is that the only thing that matters is to ensure that we will have a quantity and variety of speech. And the free market of ideas will figure everything out in the very end. We will have truth in the very end, as long as we ensure that there will be quantity and variety of speech. But this narrative doesn't actually allow us to understand what is wrong with fake news very well, and why it's so problematic for democratic practices, because fake news is actually increasing the variety and quantity of speech that we have in the market of ideas. So it seems that we need to acknowledge that there is something being sacrificed whenever a negligent information, false information of someone is shared, or a false statement is made. We need to actually be able to say what is wrong with that if we actually want to understand what is problematic about fake news. Okay, so and what questions do I want to answer in relation to defamation? Well, the first one is, are we sacrificing anything important by protecting negligent dissemination of false information of public figures from civil liability? Secondly, if we are sacrificing anything important, should judges acknowledge that loss? Is it important for them to acknowledge it? And finally, do any residual or secondary obligations arise from the fact that reputation was overridden? Okay, so that was very long and complex, probably, and so what I'm going to do is I'm going to try to explain this a little with more detail. And to do that, I'm going to divide this presentation in 4 parts, and hopefully I will get through the 4 of them. I think I will. So the first part is going to be an explanation of what moral remainders are. What's the relationship to regret and other reactive attitudes like guilt? And what are residual obligations? And what the relationship is to moral remainders. That's part 1. In part 2, this presentation, I'm going to explain the difference between specification and infringement approaches and their use in comparative freedom of speech jurisprudence. So I'm going to try to show you that this discussion that has happened in ethics without lawyers paying too much attention is actually important for us as well. And to a certain degree, what is happening in law is also important for people working in ethics, but still, so this discussion is common to both of us. We should pay attention to what's happening in both camps. And then in the third part, and the third and fourth part are the tentative arguments that I will try to make in my dissertation. So the third part, in the third part, I'm going to give you the reasons why I think an infringement approach is better at accommodating moral remainders and inducing their identification, in contrast with a specification approach. And finally, in the fourth part, I'm going to tell you why I think acknowledging moral remainders is valuable. And I'm going to provide a different at different reasons why I think it's valuable than the ones that would be provided by other academics who have been studying this, because they have, I'm not going to talk about this unless you ask me to talk about it, but most people who have emphasized the importance of moral remainders are doing virtue jurisprudence. So they think that to determine what judges should do, judges should think, what would a just judge do? What would a virtuous judge do? That's the standard they should be striving for. And I think that's problematic for several reasons. And one of them has to do with the fact that not all our judges are virtuous. And asking them to simply try to be virtuous, maybe it's not the best idea for them to actually do the right thing. So I actually want to concentrate on rights instead of virtues and try to provide a defense of moral remainders that is based on a deontological or consequentialist approach. It's either rights or consequences, not virtues as such. But I promise I will not talk too much about this unless you ask me to. Okay, so going to part one. So what are moral remainders? So moral remainders, the concept of moral remainders was introduced by philosopher Bernard Williams in a paper by him titled Ethical Consistency. And this paper analyzes moral dilemmas or conflicting obligations, conflicting moral requirements. And what Bernard Williams says is that it's clear from our ethical experience, from our life, the fact that we face small moral dilemmas in our life all the time. And it's very clear from our ethical experience of those dilemmas that sometimes you have the dilemma, you cannot comply with both obligations that you have. You will have to only comply with one of them. And you may be able to determine what is best to do in the situation, but there is still going to be a remainder. So the requirement that you're not going to comply with, that you're not going to actually fulfill, still apply to the situation, even though you cannot act upon it. And he says that that's why he calls this a moral remainder. It remains, even though you will not be able to act on it. And he says that the fact that this residue or remainder persists is expressed by the fact that we feel sometimes regret when we have to make these decisions. Even once we know what the best course of action is, we still feel regret. And we may also have a moral impulse to make it up to people who were involved for the claim that was rejected. So there are three things that are important here. I'm going to give some examples because this is not, I think it's very intuitive with the examples, but without it, it's not that intuitive. So there are three things that one needs to distinguish here. So the first thing is the moral remainder, which is the ought that was not acted upon, the moral requirement that was not fulfilled, because there was another moral requirement that was incompatible with it, and one thought was more important, that had to prevail. So the second thing is these residual reactive attitudes, like regret in some cases, or even guilt about what one had to do. So one could not comply with both obligations, one only complies with one of them, and you're going to feel some regret about it. And it seems to us, I think, we have very strong intuitions that feeling regret in those situations is justified. That someone who doesn't feel regret in those situations is doing something wrong. At least is respecting the claim that was not acted upon. And finally, there are residual obligations. So once you may not be able to comply with this obligation, you have to work someone. And the fact that you are not able to fulfill the obligation is going to lead to secondary obligations, to residual obligations. So you may have an obligation to explain, an obligation to apologize, or even an obligation to compensate the person for what you didn't do. I'm going to give two examples of this. I'm going to start first with the famous philosophical example, and then I'm going to go to a very more familiar example for most of us, I think. So the famous philosophical example is an example made by Joel Feinberg. So Joel Feinberg asks us to imagine that we are in a blizzard, and we realize that we need to find shelter, or if we don't find shelter, we're going to die. But the only way to find shelter is to trespass someone else's cabin, and that makes a dilemma arise, because on the one hand, it's permissible for us to try to save our lives, but on the other hand, the right to property of the other person prohibits us from trespassing without their permission, but the person is not there. So we need to decide which of the two moral requirements we're going to fulfill. And I think it's obvious that we should save our lives. So we trespass the cabin. In order to keep warm, we burn some of the furniture of the person. And Joel Feinberg, and I agree with this, Joel Feinberg thinks that this is justified. So you're infringing the right to property of another person, but you're doing so justifiably. You had good reasons to do so. But that doesn't mean that the right to property did not exist. Like there is a temptation to say, oh yeah, the right of property does not include a prohibition from people trespassing whenever they need to do so when they need to survive. Joel Feinberg denies this. Joel Feinberg says no, that the right to property did exist and did apply to the situation. It just was overridden by something that was more important. And that's the reason why he thinks this explains the fact that it seems that we should feel at least gratitude towards the person whose furniture we burned. Probably a little bit of regret, like we should tell him, like, believe me, I really didn't want to do this. I tried to survive a minute longer and I couldn't do it anymore. I had to trespass your cabin. And he even thinks that we should compensate him for the damages that we caused if we can do it. And he thinks this is all explained by this remainder, by the right to moral property that remained, the residue of the moral conflict. Another example, the more familiar example, has to do with promises. So something that I find very interesting about morality, which is actually very similar to law, is the fact that we can alter the obligations that we have to a certain extent through promising, through voluntary acts. But the fact that we can do that also leads to situations in which we have conflicting obligations more regular than not. So imagine you promise your best friend you're going to go to his wedding. You're going to be the best man. You have a very important role to play in the wedding. But then a family member of yours gets sick. And you need to decide what you're going to do because you have a duty to care for your family member. But at the same time, you have the duty to go to the wedding. You promised you would be there. So you have this dilemma, and you end up with the judgment that the best thing to do is to take care of your mother, of your family member. Does that mean that you didn't have the obligation to go to the wedding? I would say no. That's not the right conclusion to reach. The right conclusion to reach is that you are overriding that obligation because that obligation was overridden by something that was more important. But you should still feel regret about the fact that you're not going to the wedding. If not, you're a bad friend, probably. You should express it, and then you have residual obligations towards your friend. You may have to at least explain why you didn't go. Like you cannot just say, oh yeah, my mother is sick, therefore I'm just going to stay home and take care of her, and I'm not going to the wedding, and I will not say anything to my friend. Like that doesn't seem to be the right thing to do. You need to actually at least explain the situation, maybe even apologize. And if you're a decent person, you would probably send him some flowers as well. That's and maybe a little bit more controversial, but still, at least it would be a Mexican practice for sure. Okay, so those are the two examples that I wanted to give. I have some other examples if you want to hear them later on. So let me go to part 2 of the presentation. So what are these specification and infringement approaches? Okay, so in ethics, there have been like two camps, two groups, or two different approaches to solve human rights conflicts. So the first one is a specification approach. A specification approach involves a single-step procedure in which conflicts of rights are solved by reducing the scope of the rights. So whenever you see a conflict between two rights, the conclusion needs to be that the conflict is apparent. The problem is not something with reality or the rights themselves. The problem is something with our understanding of morality. We need to actually reassess our understanding of the rights in question, and we're going to reduce the scope of at least one of them. And by doing so, we eliminate the conflict from the picture. At the very end, you only have one obligation. And usually, when someone adopts this approach, people who adopt this approach usually think that moral rights have infinite or absolute stringency or strength or importance. So they're absolute. They always prevail over any other consideration. And that explains why they need to reduce the scope of rights, because if they didn't, it would be impossible to determine what to do. Both of the rights would have absolute strength, and there would be like an impasse, an impossible obstacle to determine what to do. The other approach, an infringement approach, resembles a lot the proportionality test, which I think you are familiar with. It's a two-step procedure. In a first stage, you determine what the scope of the rights are. So it's not that you don't care about the scope of the rights. You think about the scope of the rights, but you accept the fact that even when you really try to get the scope of the rights right, they may still conflict. And that leads to the stage in which you have to determine which right has greater weight or stringency. The right that has greater weight of stringency prevails, and the one that doesn't is overridden and is justifiably infringed. And therefore, they have this distinction between violation and infringement. So you violate a right if you do so unjustifiably, but you can infringe a right. You affect the right, you undermine it, but you do so to protect or to fulfill an obligation that has greater stringency or weight. So very quickly, so why am I talking about this? Because right now I have only talked about ethics and morality and the discussions in those camps, and it's not clear that this is that important for law. There is a very famous paper by Frederick Schauer who analyzes two different approaches to solve conflicts involving freedom of expression. So two approaches to adjudicate cases involving freedom of speech. And he calls these two approaches the American and non-American approach. So in the American approach is a specification approach. So usually, this is not always the case because common law is full of inconsistencies, and for someone coming from a civil system, it's like very impressive to see how the system works. But still, in the American approach, judges, what they usually do is they have a conflict. They see that freedom of speech may, for example, enter into conflict with reputation. And the only thing that they will do is to actually ensure that that act that is in play can actually count as speech. So they're only going to analyze if it actually falls within the scope of freedom of expression, because freedom of expression is understood to have infinite stringency. It's an absolute right. You can never infringe it or violate it permissively. And therefore, the only thing that you need to do is to ensure that the speaker acted within the scope of his right. In contrast, in the non-American approach, it is accepted that freedom of speech can conflict with other rights, and sometimes it will not prevail. You actually contrast the weight or importance of the rights in question. And what is very interesting is that in this discussion of which approach to take in freedom of speech cases, the importance of acknowledging moral remainders has never been considered. So that's more or less the gap in the literature that I want to fill. I'm going to part 3, and I'm going to hurry up because I don't have much time. Part 3. So why do I think that the infringement approach is superior with regards to acknowledging moral remainders and inducing their identification? Well, mainly because the specification approach presupposes a conception of morality in which our obligations actually, at least the obligations that derive from rights, do not actually conflict. Like it's an harmonious, morality is harmonious from this perspective, because you always solve the conflict by reducing the scope of rights. And when you do that, you eliminate the most intuitive ground for the remainder or loss, because the most intuitive ground for that loss is precisely that right that you thought was going to be overridden. But if you're just reducing its scope, then it's not applicable anymore. So in order to explain or accommodate moral remainders, or at least these attitudes of regret and this obligation to explain, someone who adopts the specification approach would need to find an independent value somewhere else that can ground this. They would say, well, yes, you feel regret, but it's not because you infringed your right, it's because of some other reason. I don't know what it is. You have to find another value that is being affected or that grounds these reactive attitudes and obligations. And it may be possible to do so in some cases, but I really suspect it's not easy in most of them. In any case, even if it was possible to identify this independent value that is being infringed, it's still true that this approach doesn't actually increase the likelihood that we will identify this loss. And it doesn't do so because it only asks us to think about the scope of the right. It's not asking us to see whether something is being sacrificed. So I think it would be very hard for judges when solving human rights conflicts to additionally say, okay, I've solved the conflict by reducing the scope of the right, and now I'm going to additionally consider whether there was another value, independent value, that grounds the expression of regret and some subsidiary obligations. That seems to me to be extremely hard. It seems to me way easier for judges to act correctly, to express regret if it's valuable, and to identify residual obligations if they are there. If you tell them, no, I need you to focus not only on scope, but also on what is being sacrificed. See if something is being sacrificed there. That will force them to see it clearly. So I think infringement approach is superior, both because it can allow us to better accommodate the fact that moral remainders exist, explain that they exist, but they're also better at inducing us to see the moral loss. And that is for me very important, because I don't think judges are always, I've worked with very wise judges, incredible people. I have no doubt about that. Many of them are incredible, are extremely virtuous, extremely brave, but that doesn't mean they're perfectly virtuous and they're going to immediately see all of this without taking into account the methodologies and decision procedures that. So we need to be careful about decision procedures and procedural design, because that's going to change how judges are going to solve cases and what they're going to do. That's part of the reason why I don't like virtue jurisprudence too much, because I think it doesn't pay too much attention to these aspects. Okay, now the final part, and I know I don't have that much time, but it will be quick. So the final part, why do I think that acknowledging moral remainders is valuable? So I would suggest three different reasons. So the first one is that acknowledging moral remainders, in my opinion, has expressive value. When you acknowledge that there was a loss and express regret for it, this is in itself a way to show respect for the claim or interest of the person who suffered the cost. So the Inter-American Court of Human Rights, likes to reiterate all the time. It says all the time that the acknowledgement that a right was violated is in itself a form of reparation. You may not get something else, but acknowledging that the right was violated is in itself already a form of reparation. And I agree with this. Not acknowledging that someone's right was violating is a form of revictimization to a certain extent. It's showing disrespect to the right. But the fact that you cannot compensate reputation doesn't mean that you cannot acknowledge that it was violated. So you have ways to show respect towards the claim that was violated by acknowledging the loss. And that already makes the situation a little bit better, at least from the expressive point of view. But this is not the only reason why I think this is important. I also think it is important for instrumental reasons.
2 minutes,
Yes,
Jorge,
2 minutes.
sorry.
No, it's fine, it's fine. I also think it's important for instrumental reasons. So it's important for instrumental reasons inside of the judicial process. So first, I think that if you ask judges to acknowledge and see the moral remainder, they will try harder to make sure that the conflict cannot be avoided. Because they know that whatever they do is going to involve a sacrifice. So if they realize that if they reach the conclusion, if they just disappear the obligation, they're going to feel very good about it. They're not doing anything wrong. No one is being hurt. Instead, if you're forcing them to see that they may be sacrificing something, they will try to find alternatives to comply with all the obligations that are at stake. And if that's not possible, it's also valuable because they may think about residual obligations that can be met without infringing the other right. So, for example, they may think about the possibility of providing declaratory relief in cases of defamation. So the defamed person may not be able to recover damages, but at least the court can say, well, I can declare that what was said about you was false. I can do that because you proved that in this trial. I can do that at least for you. And you're worried about your reputation mainly, not the damages. So let's at least do that. But finally, I'll finish with this. Finally, I think this also is important for instrumental reasons outside of the judicial process. Because we do not only think, cases, judgments, trials are one fora in which we're actually thinking about our moral obligations as citizens. And I'm very concerned about the fact that the way in which judges conceive this conflict is going to affect the way in which we conceive it ourselves outside of the judicial process. And what the courts are saying to people is, yeah, negligent defamation is not that problematic. Just worry about the quantity and diversity of speech. Don't worry too much about whether you actually verify the information. As long as you're not insincere, it's fine. And I think that's very problematic for how our information system works, our information practices. I think instead, judges should try to encourage us to adopt a disposition to be very, very accurate when we're speaking. So that's what my research is about, and I hope you find it interesting. I'm looking forward for your comments. Thank you.
That was absolutely fantastic, Jorge. Totally intriguing. And yeah, I mean, very, very complex ideas explained in a way that is, really accessible. All the way through, I was thinking about how this applies to children and young people. Obviously, dis and misinformation, a huge, huge issue for them as they kind of progress through their lives. So yeah, fascinated to see what conclusions your research comes to. But I'm going to be asking myself the question, what is being sacrificed from now on when it comes to this sort of matter? Mark, would you be willing to kind of share your initial thoughts, and then maybe Erini after that? Is that all right?
Sure. Thanks very much, Jorge. Essentially, I can repeat everything that Diane said. I thought that was a very clear presentation, very, very confidently conveyed, and a well-written paper or concept paper that you shared as well. And it's a very intriguing topic. So understanding, of course, that this is your area, and more than any of the rest of us, I will just make some observations and reactions. So I guess first of all, by way of question, if there is time, I'd be glad if you can elaborate on you said you had sort of 3 topics that you'd want to be pursuing in the project. And the first of those was whether the problem of which approach for solving conflicts of rights requires a separate analysis when it comes to legal adjudication. So when I read that section of the paper, I still wasn't clear as to what you meant by separate analysis. And perhaps that would become clearer if you can provide some examples on that, or just elaborate on it a bit more here. Moving on, you've discussed in the paper and also in your presentation this idea of you favor the infringement approach, and you suggested that you prefer it because there's more of the possibility of admitting that what was infringed was, as you say in the paper, a fundamental right, something that has special moral and legal importance. I would just query whether it's going to be true in all circumstances that what is being infringed really is a fundamental right. I know this would work in the context of your discussion of right to reputation, but there may be other situations where that's not necessarily applicable. So for me, the example of hate speech came to mind. So in Canada, as you would know, we have criminal and civil law prohibitions on hate speech, and these are implicitly affirming that freedom of expression, will be limited, right, in relation to speech that's considered to be inciting hate. So the right is it's not being overridden per se, it's being limited. And although Canada, just as much as Mexico, just as much as the US, affirms that freedom of expression is a fundamental right, when it comes to hate speech, we're essentially saying that the consideration of the legal and moral significance of freedom of expression is just no longer relevant. So that's one example, and I don't know that it's the best one in the sense that, if we start speaking about hate speech, we probably no longer have a conversation about moral remainder. But the basic point I'm trying to get at is that there may be other situations where, yes, you may favor this infringement approach, but it may not necessarily involve acknowledging the loss of a fundamental right. So I just suggest sort of a nuancing of the language there. Your comments towards the end of the paper regarding negligent speech and the reputation of public figures, I thought that was really quite interesting. One of the sort of clearest and strongest parts of the discussion. And similarly for what you were ending up on there, which I guess is one of the key things you want to be considering in the project, this sort of discussion of the value of acknowledging moral remainders. If there's just one thought I'd throw out there is that, you say you want to take an approach that is distinct from the virtue ethics approach. And obviously there's a value to distinguishing your research project, but I would caution against, fully disassociating from that sort of virtue ethics work that's out there. So, for example, in the paper you speak, and you did say this at the end of your presentation as well, you said that, there may be considerations that are being, if judges don't acknowledge losses, moral losses, the lack of that discussion may entail that we have blind spots in other areas that, we never realized that we should be focusing on these potential defects, as it were, or losses. That whole discussion that you're having, to me, doesn't seem to be that far afield from the virtue ethics focused discussion that Van Domselaar, who you cited, is having when she speaks about, the sorts of things that would be relevant to the work of a virtuous judge, right? And of course, virtue doesn't entail that judges have to have perfect virtue. It's also an aspirational concept. And she herself says that if judges are factoring in these moral cost considerations into their decisions explicitly, that could be providing valuable feedback to legislators about, downsides or blind spots in their own laws and policies. So basically, I'm saying that, yes, you might distinguish your project from the virtue ethics projects, but you may also want to consider points of convergence, parallels to what they have done. And with that, I think I will stop.
Thank you, Mark. That's fantastic. Jorge, before we go on to Erini's points, do you want to respond to that question from Mark about what you mean by separate analysis?
Yes.
You talked about your approaches. That would be really helpful.
Yes. Yeah, I didn't include this in the oral presentation right now because it's a very difficult topic. But I'm going to explain very briefly what Mark is talking about. So one of the things I added in my doctoral proposal, which I shared with Mark and Erini and Nauman, one of the things I briefly mentioned is that someone could say to me, like, Jorge, I don't know what you're doing because we have all this literature from the ethics camp already. Why do we need to analyze this in the specific context of legal adjudication? And I think that some scholars are doing this also in relation to approaches to solve conflicts of rights. What they say is, we don't have to see what are the specific conditions of legitimacy of adjudication. We only have to think what rights are. And because we're talking about moral rights that have been positivized in the law, this Ferrajoli's approach, for example, or Alexis' approach, because we're talking about moral rights that have been positivized in the law, the only thing that we have to analyze is how conflicts of rights should be decided. There is no additional question if the same approach should be taken in legal adjudication or not. You're going to have to use the same approach in ethics and the same approach in law necessarily because that's what rights require, because that's what derives from the nature of rights. And I disagree with this. I think that adjudication has specific legitimacy constraints that need to be taken into account. For example, in our ethical experience, and I promise I'm going to be short because we need to say more things, but in our ethical life, common life, every single day, like we may have to make some moral decisions, and we will make them very intuitively without having to give too much reasoning, and that will be fine in many cases, just to take intuitive decisions without providing a public justification for them. This is not possible in legal adjudication. Like the legitimacy of adjudication requires public justification that is accessible to everyone. And that, in my opinion, is one of the things, not the only one, but one of the things that would need to be taken into account when thinking about what approach to take to solve moral conflicts in the legal arena. So that's more or less what I wanted to suggest, that there is a reason to study this in the particular context of legal adjudication and to think whether different conclusions will be reached in this area in contrast with ethics.
I think we're going to have to, because I would definitely like to hear your perspectives, Erini. So if you could share, that would be amazing. You're currently muted, so please don't forget to press the button.
Yes, can everyone hear me now? Is that okay? Yes, very great presentation. Again, I'm not in your field of research, but it was really interesting and it was a great presentation, and yeah, some good points raised. I think the only points of clarification, or maybe something that you could maybe develop more, is when you were talking about moral rights or the conflict of rights and identifying moral remainders and acknowledging them, the possible like different cultural and social norms that exist and how this might influence the interpretation of these. So you spoke about the US and Latin America. So what kind of cultural and social impacts and norms and how they might influence it? Maybe you can build more on that if you've been able to identify any differences in interpretations and just clarify that a bit. I think that would be useful for maybe someone who's not in your area. Thank you, that's all I have.
Any reflections, Jorge?
Many reflections.
Pick your top one.
Yeah. So let me just say very quickly. So I presented something similar to this here at NYU at the Jean Monnet Public Law Workshop, and someone asked me something very similar to what you said. But they were trying to convince me to become a moral relativist, and I don't think your comment goes in that direction. I think rather, from what I understand, so let me try to phrase it. So I think that there are many ways in which cultural norms and practices are important for all of this, and I acknowledge that. And I do think that there can be some cultural variation, even in the way in which we understand certain aspects of rights, and that could be justified as long as a certain like basic core obligations are understood to be the same everywhere, because I'm not a moral relativist. But I agree that there should be certain variation. But I think you're right that there is something going on here about culture and legal tradition that is very important to see, because the story of the actual Mali standard is actually a story of one way of thinking about rights being transplanted to Latin America through the Inter-American Court of Human Rights jurisprudence without actually thinking how it fits with the legal tradition and cultural tradition of the Latin American countries. So I'm going to say this very quickly, and because I know there may be other questions, but one thing that worries me a lot is that just because it was the US and it seemed to be a very important and standard, we incorporated these standards without actually developing a justification for it that actually fitted our own tradition and culture. And I think that was very problematic, because in the US, the right to reputation is not a human right. It's not a constitutional right. Not in the Constitution. But in Mexico, it is. And it's not only in the Constitution, it's also in the Inter-American Convention. So it seems that the justification for the standard should have been different. And by doing this legal transplant a little bit carelessly, I think, we ended up failing to acknowledge an important loss that, at least in our legal tradition, had to be acknowledged even from a legal point of view, because the human right is there in the Constitution. Not just, whenever I talk about reputation here, people look at me like, but why are you talking about reputation? It's not even a right. I'm like, no, it is a right. Yeah, so I don't know if that, if I captured some of the things you're worried about, Erini, but that would be my comment, my initial comment.
Okay, thank you. We are super restricted for time, and I don't want to stop without giving our audience an opportunity to ask questions. So if you would prefer not to speak out loud, if you can pop your question in the chat, you're most welcome to do so. But yes, are there any questions? You've given us plenty to think about, Jorge. Oh, yeah. Really interesting. I'm minded to, you know, the applicability is of this idea of the moral remainder and what is lost and what's being sacrificed and how we kind of compensate or allow for that. It's quite Butlerian in some senses, quite Judith Butlerish, which has obviously been applied a lot more to kind of children's lives. So I'd be kind of interested in exploring that further once you've done your studies. But yeah, any other questions? Got a comment from Pascal, highlighted some very interesting considerations for adjudicating conflicts of rights, thinking of employment law and equality, reflecting on certain perspectives on certain circumstances because of how you put the concepts forward. Yes, I would agree with that too.
Diane, can I very briefly, in the meantime, if someone wants to ask something, just say something very quickly about what Mark said, because I didn't get the chance to first thank him for the comments, and it is important because I actually think both your comments and Erini's comment are very useful. I want to thank you for them. And I wanted to just briefly mention something about what you said, this idea of maybe when you resolve the conflict, what remains, if something remains, is not going to be a human right. And I absolutely agree with that. I think you are right when you say that. I actually think that supports the infringement approach as well, because the infringement approach, the first stage of the infringement approach is actually to analyze the scope of the rights. So when analyzing the scope of the rights, you can reach the conclusion, yeah, I mean, the conflict was actually apparent. Once we analyze the proper scope of the right, we realize that hate speech, for example, using the example you were giving, hate speech is actually not a human right conflict. The freedom of speech is, if correctly understood, if one sees the values that underlie the human right, does not actually entail a permission for you to make this type of statements. So hate speech is outside of its scope. But it still allows us to, in other type of cases, reach the conclusion, no, it was actually a genuine conflict. And I want to keep that possibility. I think that keeping that possibility actually reflects something of our ethical experience that is important. But yeah, I agree with you. And obviously it has some dangers to take this approach, because obviously someone who wants to defend prohibitions on hate speech regulation, for example, is going to say, well, you're not seeing the fact that something very important is being sacrificed here. They're going to try to make this a genuine conflict instead of an apparent one. And I see that problem is there. And just about the virtue ethics comment that you made as well, very quickly, like I had the great privilege of taking a class with Miranda Fricker last semester here at NYU. Has worked a lot on virtue ethics. And I would always tell her, well, I don't agree with virtue ethics, and then I would say something. And she would always tell me, well, I think you agree with virtue ethics. I actually think you're a virtue ethicist. So obviously this type of terms are very, they're to a certain degree, these labels are to a certain degree vague and controversial. So I would say that I am very, very concerned about the virtue of the representatives and public officials that we choose. So I think caring about who the politicians are that we're electing for public office, for example, is important. So I agree in that regard. I think that thinking about what dispositions we should have to act morally is very important. So I agree also with that. The thing I'm not so sure about is this idea of this particular strand of virtue ethics that thinks that what you're actually trying to do when you act morally is pursue a good life. And I actually think that morality is others regarding, mainly others regarding, not self-regarding. So this idea of the judge aiming to become the virtuous judge because that's an end in itself, that's the part that I don't agree much with. And I'm sure many people who do virtue jurisprudence wouldn't either. They would say, well, no, of course, I don't think that. So I think that labels sometimes can be very bad to think about this thing. So I agree with you, and I thank you for the comment. And I promise I'm not going to be stubborn about this. Like I am fine. If you want to call me a virtue ethicist, I would be very happy about it. It would be a great compliment.
Thank you, Jorge, for picking up on Mark's other points there. I think, as I understand, we are coming to the end of our time now, Man. Is that correct? Yes. We
Yes,
just kind of
correct.
give a virtual applause for all of our contributors, Mark and Erini and Jorge. I've had an absolutely fantastic time. Thank you, everybody.